rent-free period, rent deposit, deed withdrawal, rent reduction, rent review, break clause, negotiating an early surrender, or lease expiry. So the first question is, can a tenant bring a commercial lease to an end as a result of COVID-19? Well, the answer is no, because unless the lease contains a break right, the tenant has no right to terminate the lease. The tenant may argue that COVID-19 is a force majeure event, which is an event that is outside the control of both the landlord and the tenant and prevents the tenant from exercising its obligations under the lease. However, if there was a force majeure clause, it would need to be set out in the lease. And most commercial leases these days do not contain such a clause. And therefore, you cannot argue that. Whether in the future, when leases are drafted after the outbreak is finished, we'll see more of these force majeure clauses, that is a possibility. But for most current leases, that clause is not usually included. Now, a tenant may feel like just simply shutting up shop, handing in the keys and walking away. This is not to be advised, because until there is a formal surrender of the lease, the tenant's liabilities under the lease will continue. So that's the obligations to repair the property, the obligations to pay the rent and service charge and so on. So the tenant should not simply just walk away, because they will still be liable and the landlords can come after them. Likewise, the landlord should not accept the keys to the property if the tenant simply offers them, because if the landlord accepts that, its act of accepting the keys could amount to implying that there is a formal surrender of the lease, and then the liabilities of the tenant will come to an end. So the landlord has to be very careful about not accepting the keys until he has some formal deed surrendering the lease. So the next question, can a tenant withhold the payment of rent as a result of COVID-19? Again, the answer is no. Most leases will contain a clause that says the tenant has to pay the rent and cannot withhold any sums against it or anything like that. It has to pay the rent full and flat. A further effect of non-paying the rent is that a lot of tenants may have personal concessions, such as reduced rents, for example, undertenants, which are documented by way of a side letter. And these concessions are important. So if the tenant decides not to pay the rent, it will lose its concession and in the future will suddenly be landed with a large bill, because by not paying the rent, the concession may have ended as well. Furthermore, if the tenant say, well, I'm not paying the rent because the landlord can take the rent out of the rent deposit deed, the tenant has to be aware that as soon as the landlord takes the non-payment of rent out of the rent deposit deed, the tenant is normally required under the rent deposit deed to top up the rent. So by not paying the rent under lease, it will still be required to top up the rent payment that the landlord has withdrawn from the rent deposit deed. Furthermore, if the tenant decides not to pay the rent, but has already exercised a break clause, he could invalidate that break clause, because most break clauses require the rent to be paid up to date at the date of the break. So if the tenant had decided in March not to pay the March payment of rent, but had previously exercised the break clause to say to expire on the June quarter date, because the rent hadn't been paid, the landlord could say that the break on the quarter date in June is invalid because the rent was not paid up to date. There have been new measures, as you may have seen in the press, that the government has introduced in March, where it does not allow the landlord to forfeit the lease for non-payment of rent until after the 30th of June 2020. Now, this is a temporary measure only. Basically, tenants will not be forced out of their premises due to non-payment of the March quarter of rent. But it is only a moratorium, and after the 30th of June, the rent is still due, and the tenant is still liable after that date. Now, will that date change? We don't know, so just keep up to date with the news. Practically speaking, will the landlords actually take action to forfeit the lease for non-payment of rent? If the landlords did that, they would leave themselves with empty properties with the unlikelihood of actually renting them again in the immediate future. So some rent is better than no rent at all. The other remedies available to the landlord for non-payment of rent are still available despite not being able to use the termination or forfeiture clause. These include being able to take action against the tenant and instigate insolvency proceedings, or calling on any guarantors under the lease, or, as already mentioned, withdrawing on the rent deposit deed. So the next question, can a tenant request a rent suspension if their premises are unusable due to COVID-19 and the government legislation? A lease suspension is not a normal clause to find in the lease for non-payment of rent. Suspension is usually only allowed if the premises are damaged, destroyed, or unusable due to an insured risk. Moreover, suspension is covered on the landlord's policy. Most modern commercial leases only provide for suspension, as I've mentioned, if the premises are damaged, destroyed, or unusable, and only if the landlord's insurer offered cover under its policy terms, and this is unusual. However, as with all things, a check of the landlord's insurance policy should be made before looking at any other alternative. Sometimes a lease will allow for suspension for an uninsured risk, and if the lease does allow for that, the landlord will then need to look at his loss of rent insurance on his policy. If tenants are concerned, they should be, and probably have, been looking at their business interruption insurance. Rent review. It may be counterintuitive at this time to consider or contemplate reviewing the rent under a commercial lease, particularly where there's only going to be an upward only rent review. However, in previous crises where rental growth was established in itself beforehand, a rent review resulted in an increase in rent wasn't out of the question. The key to all this is the rent review date, and this is the date at which the valuation is made. So basically, if the rent review date is, say, end of February, then of course COVID-19 would not be taken into account in terms of any valuation. Just for example, in 2008, the lawyers who were having to deal with rent reviews at the time of the financial crisis came up with many differing valuations depending on the actual rent review date. So if it was on the 24th of June or the 29th of September or the 25th of December 2008, several different valuations came up because they were trying to account for the crisis at the time. The most important thing to say for rent review is to consult a surveyor, but it's also important to ensure that tenants and landlords with reviews this year or next year keep the information on what they and the market in which they operate know about the disease, any estimations as to its implications, and how that features in their decision-making processes at the relevant times. There are, of course, ongoing rent reviews at the moment, where these sort of issues are coming to a fore. So now the crucial question, which I think is what most people are looking at and have been looking at, is how do we stop paying the rent or change the rent payment because we have no business? The crucial thing is to talk to the landlord. As mentioned earlier, some rent is better than none at all. Now, landlords and tenants have been talking and should continue to talk, but the potential way of ensuring that the rent is paid is to offer up different examples, saying the tenant say, well, I'll pay the quarter rent, but I'll only pay it in monthly payments, so it's a cash flow issue. Or I'll offer to pay it in 6 months' time and effectively make up for the 6 months that I don't pay now at a time when everything is back to normal. So staged payment to make up the balance owed later is probably what most landlords and tenants will come to. Often tenants will say, well, we don't know what the future is going to be. We want a rent reduction, and we probably want a permanent rent reduction. The landlords have to be very careful about accepting a rent suspension or a rent reduction. They have to ensure that it is carefully and properly documented, so they need to avoid the possibility that they avoid the waiver of the right to receive the full rent in the future. And they also have to avoid the argument that by reducing the rent, the lease has been permanently varied. As mentioned before, these rent reductions or rent suspensions are intended to be temporary. Furthermore, a rent reduction may have an implication if a tenant wishes to assign the lease, because the tenant could argue that on assignment, the rent is the reduced rent and not the full rent. The landlords will also want to ensure that if they accept a rent reduction now, they have the ability to claim the shortfall in the future. So the balance to be paid in the future, and when it will be paid. Will there be interest on that balance? What is the rate of interest? Furthermore, the landlord and tenant should agree how long these temporary arrangements should last and whether there should be notice terminating these arrangements. Furthermore, if the landlords and tenants do not do things properly and document these things properly, then it potentially will have an effect on future rent review and or renewing the lease in the future. Turning to a rent deposit deed, as mentioned earlier, the landlord has a right to draw down on the rent for non-payment of rent. The tenant will be required to top up that payment if the landlord has drawn it down. So the tenant, although he doesn't pay the rent under the lease, he's still required to make the payment under the rent deposit deed. The landlord has to be careful that by exercising this right to waive, to draw down, he doesn't then waive the right to forfeit the lease after the temporary measures have ended. So if the landlord and tenant want something more permanent rather than a temporary reduction, then the landlord and tenant will have to consider whether there are any break clauses. As mentioned above, a tenant can usually only terminate a lease before the end of the term if it has a right to break the lease. Break clauses are a useful tool for both landlords and tenants. Break clauses are an explicit right for the landlord or tenant, or both, to terminate the lease at an agreed point in time. This can be a specific date or dates, or can be a rolling break, which enables the relevant party to break at any time during the lease. For a break to be effective, it will need to meet various conditions, and it is advisable to get professional advice in order to ensure that they comply with these, as failure to comply with the conditions may result in the break right not being exercised and being invalidated and the lease continuing. The common conditions are notice. Often break clauses will be drafted so that a tenant or landlord will have to give the other party 6 months notice before the break date. Obviously, the parties are required and advised to retain proof that the break notices were sent and the acknowledgement by the other party. As already mentioned, for a break notice to be valid, payment of all the rent and all the sums at the break date will need to be up to date. So if the rent is paid quarterly, this may mean paying the rent and other sums due beyond the rent payment date and include any sums of money for rents or other sums that they have not paid previously and are effectively late sums. Thirdly, most importantly, exercising the break means the tenant will have to give up vacant possession of the lease. This means the tenant will not only have to surrender the lease and the document, but actually physically move out of the property and remove all its possessions, fixtures and fittings so that the landlord can actually use the property. Failure to remove its possessions will lead to arguments about whether the break is valid or not, because the landlord cannot use the property if the property is still full of the tenant's fixtures and fittings and possessions. Not so normal now, but certainly it's worth checking every lease, is to whether the tenant has complied with its repairing obligations. Quite often a lease will state that it needs to have complied with its repairing obligations at the date of the break. This means that it needs to have kept the property in good repair, and it ought to check all its obligations under the lease before actually exercising the break, so as to be sure that there will be nothing that will catch it out at the break date, which would then threaten the validity of the break. Break clauses, as mentioned, often require the tenant to pay the rent up to the break date. Now, if the break date is not on a quarter date, the tenant will have paid the rent beyond the quarter date, and likewise may have paid the service charge beyond the quarter date. Some leases will have been, if drafted properly, will require the landlord to refund those rents and service charges that go beyond the quarter date, assuming the quarter date is the or beyond the break date. Furthermore, one should look at the break to consider whether it is personal to the named tenant on the lease. This is crucial in terms of whether the tenant can actually exercise the break. If the tenant has taken a lease or bought a lease from somebody else and the break is specific to the previous tenant, then that tenant will not be able to exercise the break because this is personal to the original tenant or the previous tenant. The most important thing is to talk to the landlord before exercising the break, to give them notice that this is what you're intending to do so that you are aware of any potential problems in exercising the break. This is because once a break notice has been served, it cannot be withdrawn. If it can't be withdrawn and the landlord and tenant then decide, well, actually things aren't quite so bad and we can go back to how it was, actually this causes a legal problem because the break will potentially have broken the lease, and if they want to go back to the position where they were before the outbreak, then that would probably require the drafting of a new lease. Furthermore, at the break date, the tenant, as well as giving vacant possession, will have to yield up the property, and this will be in accordance with its repairing obligations. This may mean removing the alterations that it has installed and so on. So one has to read the lease and check everything before exercising the break. Now, very briefly, there are two types of lease. Break clause, and one has to consider the break clauses in terms of a lease that is excluded from the landlord and tenant security of tenure provisions, and one that is in a lease that is protected, which is inside the security of tenure provisions. Basically, there are two types of lease. If the lease is included and has the security of tenure provisions, that means at the end of the contractual term ends, but a statutory term continues. This is very important because effectively the tenant will still remain liable for all its obligations, including the payment of rent, once the contractual term ends, because a statutory term has been instigated. For a landlord, if the landlord has a break notice in a protected lease, he would also be required to serve a Section 25 notice, because a break notice simply brings the contractual term to an end, but in order to bring the statutory term to an end, a Section 25 notice would be required. A Section 25 notice to obtain possession from the tenant is very difficult to obtain because it has very strict conditions, and these include requiring the landlord to prove that he wants the site for redevelopment or for his own use. So it's quite unusual for a protected lease to have a break notice in, because the landlord already has the requirement to serve a Section 25 notice to bring the lease to an end. A tenant's break notice in a protected lease simply operates as a notice to quit. In a lease that is excluded from the landlord and tenant provisions, then once a break notice is served, the lease ends on that contractual date. Finally, if there are no break clauses, the tenant can try and negotiate a formal surrender with the landlord, which will often require payment of a premium and a formal deed of surrender. And if the landlord doesn't agree to a surrender, then the only option is to wait till the expiry of the lease. And as mentioned, in a lease that is excluded from the Landlord and Tenant Act, then the term expires on the contractual date. If we are talking about a lease that is protected, then under the 1954 Act, a further 3-month notice would be required to be served by the tenant on the landlord to bring the statutory term to an end. The only requirement for the tenant to be able to serve this notice is that he will have been in occupation for 1 month. And again, like any notice, once served, it will be irrevocable. Thank you very much. And if you have any questions, please do not hesitate to raise them or get in contact.
So thank you very much, James. So we now just open the floor if there's any questions. I'm just checking, there are a few questions. There's a question which has been asked. So it says that my lease expired 18 months ago and terms have broken down over a new lease, presumably negotiations. Can I simply walk away? Which is a question, thank you. So the lease expired, and I'm just going to bring in at this point another panelist, which is Daniel Flynn. So Daniel is a litigations partner at the firm, and he is here also to answer any questions that you may have. So I'm just going to invite Daniel to come on board.
Hi.
Yeah, hello there. So, right, so just bear with me a second while I get, right, okay, here we are. So welcome, Daniel. Daniel, the question is, my lease expired 18 months ago and the terms have been broken down over a new lease. I think he means the negotiations. Can I simply walk away from the expired lease? James, did you want to comment on that?
The second question.
Yes, yes.
So the question is, my lease expired 18 months ago and terms have broken down over a new lease. Can the tenant just I'm assuming this is the tenant just walking away. This does depend on whether the lease is a protected lease or non-protected lease. If it's a non-protected lease and the contractual term expired 18 months ago, provided the tenant has removed its possessions and so on and left the property with vacant possession, then the tenant is likely to be able to walk away, unless, of course, the tenant has paid the rent on the basis that it used to pay the rent, in which case it may be required to give notice. So if the tenant had paid a quarterly payment after the contractual term had expired just to continue occupying the property, then effectively a form of tenancy at will may have been created, and the tenant may be required, if he's paid 3 months rent, to then give 3 months notice to terminate effectively the unwritten tenancy at will.
Dan, did you want to add anything in terms of the walk away and what could happen in terms of any potential litigation?
Just where someone has walked away and a landlord is thinking about enforcing the obligations under the tenancy, as James says, that there might be a tenancy at will created, and there might be a kind of an expectation that rent will be due and that there'll be notice due from the tenant. The landlord might have some difficulty in enforcing that, because the court will say you could have just let the property out again, and that would have been how you would have got that money back, is just by putting the property back on the market and getting a new tenant in. So you would be limited, I think, to recovering from that sort of tenant money, rent, for even if there was a notice period implied, for a reasonable period for reletting the property.
Right, so we go into the next question, thank you, which is, I mean, one question obviously, and I think it's a really relevant question, is that can I let someone who wants to use my property and who will effectively pay me the rent? So, you know, it's a very neat way of getting out your obligations. James, is there a way of you can just simply walk away from this neat solution?
Well, again, the question will be, you'll need to check the terms of the lease, because effectively what you are dealing with is you're dealing with the alienation clause in the lease, because an alienation clause will confirm who can use the lease other than the named tenant. And if you're allowing somebody else into the property, you are effectively assigning that lease to someone. The other issue is that if you're sharing the rent, if you're allowing somebody else in, the issue for the landlord is that the landlord doesn't have a contractual relationship with that tenant and would not probably allow it unless there was some formal assignment to the person who is sharing it, even if it's an assignment from the existing tenant to the existing tenant and the sharer.
Daniel, did you want to talk about that? Because it's literally walking away from your responsibilities, but then having this additional party who's effectively in your shoes, effectively.
I mean, where there's an obligation to pay rent as a tenant to a landlord, you've got to formally end that obligation. The risk is that you say, "Oh, I handed over to my subtenant and they've taken over the lease from me." The landlord will say, "Well, I don't have any contractual relationship with them. My relationship is with you." So even though you've walked away from this, you're still, while I'm still not able to get possession of the property back, you will still be liable for defaults of this new replacement tenant potentially.
I suppose you could also add that the landlord should probably wouldn't accept rent directly from that new tenant in any event, and so it'd have to still come through you actually. So just be wary of that. They won't accept rent directly from someone else that they're not aware of. One other question that's come up is to do with rent deposit deeds, James. So rent deposit deeds. So the landlord has asked here that his tenant wants to use the rent deposit deed. Is that a good idea? And it seems, again, very neat. You know, he's got that money stashed away. Why not dip into it?
Well, as I said, the landlord can dip into it and he can withdraw the rent, but there's usually a requirement in the rent deposit deed for the tenant to top up that amount within a certain period of time of the date of withdrawal by the tenant. So although the tenant isn't paying the landlord the rent in the normal way, effectively he's still being required to pay to the landlord the amount by which the landlord has withdrawn. So effectively, he will still have to pay the money into the rent deposit deed. So although not paying the rent, he's still having to make a payment to the landlord to ensure that the rent deposit deed is topped up.
And if an arrangement is accepted, say by the landlord, that's a good idea, and in what form would you want to sort of try and record what the arrangement is? How would it be recorded?
Well, it would probably need some formal side letter or agreement to document that, so that it's in writing and then attached to the rent deposit deed.
Yeah. Fine. Dan, do you want to add anything in terms of sort of messing around with the rent deposit deed, and then non-payment after that? Let's say if you want to sue after that, the tenant doesn't pay to top up the rent deposit deed. What recourse does the landlord have?
Well, I mean, apart from suing for unpaid rent, taking the money for the rent deposit deed, if it's a term of the tenancy that the rent deposit deed is kept properly topped up, which it probably will be in a modern commercial lease, then it would be a breach of the tenancy for the purposes of potentially bringing the tenancy to an end, potentially looking at getting the tenant out. And once you get them out, you would then, in the course of those same proceedings, be able to ask the court for an order that they kind of pay up to date. So you take the money that's in the rent deposit deed and get an order from the court that the tenant should pay anything that's outstanding.
Right. So the next question is really something that everybody is a really good question, very pertinent, and that is that if the landlord is approached by the tenant on the view that, with the view that actually you want to have a moratorium on the rent, and let's say you give 3 months grace, how does it really fare in terms of the landlord's rights? And then obviously, if the landlord is then stuck with the situation where either that 3 months is not recovered and they don't pay, or they don't start repaying the rent. So we have a situation where landlords are listening, and they are aware of the situation, and they are trying to help tenants. They try and help the tenant, but the tenant then is unable to then continue with paying the rent. What's the situation now? I'm going to go to Daniel on this because it's more litigious. So there is a sort of an agreement in place that there is a three-month waiver. After that, the tenant stops paying. What's the situation with the landlord's rights? Because clearly he's given some leeway.
I mean, giving leeway in a temporary set of circumstances, as long as everything's done in a way which is clear and in writing, wouldn't affect the sort of overarching obligations under the lease. So I think if you were to say, I've given 3 months leeway, but that's all I'm prepared to give, and then after that the tenant still doesn't pay, then it's their obligations continue as normal. So you'd effectively say, like, it doesn't change the position that they've got to start paying rent again after those 3 months are up. I think so I've seen on the chat that somebody's asked about a month rent free, but that it's not that's not going to help, and that she's thinking about serving a notice in order to end the tenancy. And it's a similar point, the two things about a month rent free and about the ending of the tenancy, or the obligations under the tenancy while it continues, are pretty independent of each other. So if there's been a month waived, then that's fine, and that's an agreement that you've reached between your landlord. The obligations to serve notice under the Landlord and Tenant Act to end the tenancy, or to go through the formalities of the tenancy, aren't really changed, and that rent-free agreement, that rent-free month agreement to have a month rent-free is is a separate freestanding agreement which just affects that 1 month. It doesn't affect the other obligations under the tenancy. Right. So in answer to the final question, in the last sentence of that question on the chat, can I take the month free and still serve notice? Yes.
Yeah, okay. And just on waiver, Daniel, is the waiver, how should the landlord deal with waivers? Because landlords are always told unequivocally by solicitors, don't do anything that will create a waiver of your rights. So how is the landlord really going to protect himself, even though he's trying to be helpful?
I mean, I think the first thing to think about is the landlord. There's a number of different ways of dealing with this situation. It is a very challenging situation for all businesses and for all commercial tenants and landlords, but there are different approaches depending on the circumstances. So the first to think of is what's going to be the effect on the business that's the tenant business. Are they going to be able to afford to make up the money when it's due in the future? Because perhaps I could say I'll defer rent rather than waiving it. If I'm going to say I'll just have a rent-free period, then that's fine too. But I think the important thing is to make sure that everything is done in writing and in a way which is clear. So, and when I say clear, what I mean is clear in what you're proposing. So I propose that instead of the rent being X £1,000 due in June 2020, it will be Y £1,000 or zero. But that will not affect the other obligations under the lease regarding rent in the future or service charges now, for example, or any other costs now. I think, the two sort of overarching points are enter into a dialogue between landlord and tenant and make sure that you don't do anything unless it's clearly documented in a letter, and ask a solicitor if you want help in drafting a letter. This can be a major, expensive, big money commercial decision that you're making. Do think about getting a solicitor to look over any waiver agreement that you decide to enter into.
So we're sort of coming to the end, but there's one question which is not on there, but it's is really the final bit, which is really on terms of non-payment. In the end, does the landlord go in and with a sledgehammer and effectively repudiate or just call it quits with the tenant? I mean, what's the advice from panelists as to just clear cut can't pay rent at this moment in time?
Well, I think that basically, I mean, if the landlord just wants to have a permanent break with the tenant, he probably needs to consider whether he can let the premises out to somebody else. And as mentioned earlier, that may not be so easy currently. So some rent or some payment may be better than none at all.
Daniel, did you want to say anything?
No, I think I'm happy with that.
Okay, good. So last question, I think. Hi, my landlord has given me 3 months rent-free period in writing. How can I ask for more?
There's a dialogue with your landlord. The starting point is that your commercial lease contains an obligation to pay rent, and COVID-19 doesn't change that. But on the other hand, I'm sure that landlords of good conscience and will be able to try and work something out.
Thank you so much, James and Daniel. So next week is a really thorny webinar, and that is buying and selling property. Are you serious? ? So we're going to try and really answer some of those questions which people are asking, whether you can buy and sell now. So thank you everybody for coming on board this beautiful Wednesday afternoon, and we'll see you next week. Thank you.
Thank you.
Thanks very much.